Now, I would like to call upon the plaintiff counsel and the defendant counsel.
We will be hearing the arguments presented for the case of Mr. John and Aminah. The date is 15 November 2022. The facts of the case are as follows. The defendant, Aminah, was driving a Honda City on the Duke Highway in the afternoon. She suddenly hit the plaintiff, Mr. John, who was on the road as his car had broken down and was waving for help. So Aminah was driving at 100 kilometers per hour and was hurrying home at the time because her 4-year-old son was crying in the back of the seat due to a serious stomach ache. So this court is now in session. The first counsel for the plaintiff may present her case. You have 2 minutes to present your case.
Yang Arif, it pleases this honorable court, I am Ayra representing plaintiff Mr. Johar. Yang Arif, I have 2 grounds of contention from Ms. Speaker 1 to present in my submission. Firstly, defendant speeding on the highway is not justified. Second ground, defendant exposed other road users by driving under distraction. I shall require 2 minutes for my submission. If the bench does not have any preliminary inquiries, may I proceed with my submission?
Yes, you may.
As the first ground, applying the preceding case where Muhammad was said to have driven recklessly, the material facts are identical to Aminah, since I argue that Aminah has sped at 100 km per hour, which can be considered reckless, as it should be mentioned that the incident took place on Duke Highway. Per as the highway speed limit, Aminah had exceeded the speed limit since the Duke Highway maximum speed limit only allows for 90 km per hour. As a result, Aminah violated the Section 42 of the Road Transport Act. Therefore, it should be within her judgment and expectation to drive according to the road regulation despite the nature and the road condition. It will be hard to control the car if there is hazard that emerges suddenly, as the time windows for a car with high momentum to stop completely will take longer time. Therefore, due to her reckless driving, it is foreseeable that Aminah failed to comply with traffic safety. So, on my second ground, when Aminah was on the road, she was distracted by her 4-year-old son who was crying in the backseat due to a severe stomach ache. Plus, as the fact only highlighted that her son is in the back seat, not a child seat, which kids her age shall use while traveling, her child can be assumed as a great distraction to her as a driver. In the preceding case, Muhammad's attention was distracted as he used his handphone while driving and ran over Granny Winnie. As Muhammad was found liable for negligence. Identical fact applied in Aminah was also distracted by her kid's medical condition. Young Arif, however, is not a reason for her not to abide by the road safety regulation and expose other users to a higher degree of danger. Young Arif, she would be found liable for breaching the duty of care that was expected from a reasonable person.
I'm Intan, the co-counsel, will be presenting the third ground and the fourth ground. For the third ground, during the incident where Aminah was driving, it was on a sunny afternoon and the sun was shining brightly. In the case of Granny Winnie and Muhammad, his appeal was dismissed because when he was driving, the weather condition was excellent and he could see the road clearly. Relating with the case of John and Aminah, it was also on a sunny afternoon, which shows that she could logically see clearly anything on the road. Young Arif, the fact that it was shining brightly gave her no reason to say that she could not see John on the road. This will be discussed differently if the incident happened at night, where there was no street light when Aminah was driving. Young Arif, Aminah should have adjusted her speed limit or used other tools to accommodate the bright weather, and she should pay attention to the road or slow down to deal with the bright weather. Aminah's claim regarding the weather condition was unreasonable and will be held accountable for the damage caused by her own negligence. And the fourth ground, in the precedent case, Muhammad is held liable since the elderly crossed the road on a zebra crossing, which is a lawful crossroad. As in this case, John was waving frantically, asking for help. Young Arif, there is no evidence in the fact that indicates that John was standing in the middle of the road, which according to the reasonable man test, that would be considered as a dangerous act. The case would be different if John stood in the middle of the road waving for help. He would be liable as he was an irresponsible road user. Young Arif, the act of John lawfully standing on the road, on the side of the road was hit by Aminah, who was driving recklessly, showing the evidence of negligence from Aminah. Plus, as per the common law, it's not illegal to pull over on the left side of the road if your car were broken down. In many cases, that's what the highway shoulder and emergency lane are for. Young Arif, assuming John is a reasonable man, he will use the emergency lane, which is situated on the most left lane, to pull over. John could prove that he had no chance of avoiding the incident since Aminah is the one who was speeding on the left lane. Hence, Aminah would be liable for negligent driving. Thank you, Young Arif. That's all from us.
Okay, you may proceed.
Young Arif, if it please this honorable court, I am Ahmad Zaim Suhail bin Ahmad Mujahid representing my client Mrs. Aminah. Young Arif, I have 2 grounds of contention to present in my submission today and another 2 grounds of contention from my co-counsel. Firstly, the speed limit of the car, and the second ground is the condition of the weather. I shall require 2 minutes of the court's time for my submission, while my co-counsel require another 2 minutes, and we will require another 1 minute for rebuttal. So if the bench does not have any preliminary inquiries, may I proceed with my submission?
Okay, you may proceed.
So the first ground of our submission is the speed limit of the car. Young Arif, the counsel from the plaintiff's side cannot apply the material fact in the case of Granny Winnie and Muhammad with our present case for today. This is because in the precedent case, one of the reasons the federal court dismissed the appeal is because he was speeding, which was 18 km per hour in front of a zebra crossing road. And compared to our case, it is unreasonable for a driver to speed their car when he approached the zebra crossing. This is because people will use the zebra crossing. And compared to our present case, my client drove her car on a Duke highway, not across the zebra crossing road. Plus, we can submit that the speed limit to drive on the highway is 110 km per hour based on the National Speed Limit Orders 1989. And here, my client did not drive exceeding the speed limit. She only drove 100 km per hour. The second ground of our submission is the condition of the weather. Referring to the precedent case, the condition of the weather at that time was clear and Muhammad can see the road clearly. Thus, it cannot be argued that he was liable in negligence. However, for our present case, the condition of the weather at that time my client drove her car was sunny afternoon and the sun shined brightly, which can cause my client to not really see the road since she may be blinded with the sunlight. Hence, the material fact of the case is different with the precedent case. Thus, the counsel from the defendant should not apply this case for the submission. That's all from me. Thank you, Arif.
Young Arif, I'm Nurul Izza, represent Aminah as a defendant, and I totally disagree with the fact that has been brought by Mr. John Counsel. So, Young Arif, my argument is my client was not distracted by her 4-year-old son who was crying in the back seat due to a serious stomach ache. Meanwhile, in the Muhammad case, he was obviously distracted with his phone as he was busy talking to his friend while driving. So, a reasonable man should take the precaution of using phone while driving because it leads the person to use only one hand to handle steering, which can lead to any dangerous thing bad happen on the road. So, Young Arif, comparison with my client case, she drove her car with both hands and she did not communicate with her kid at that time, but she was hurrying to reach home as her kid was in a pain. So, Young Arif, for our last argument that we should distinguish on the base preceding decisions as Muhammad was held liable as the lady, Granny Winnie, was lawfully crossing the road at the zebra crossing. However, in the present case, Mr. John, who was on the road, the car had broken down and just waving for help would be deemed unlawful. So it can be said that it's unlawful for Mr. John to park his car on the road as she should report it to the Duke Expressway operator instead of waving and trying to stop the other road user. So not only that, Mr. John should put the hazard triangle to alert other drivers so that he was not hit by the other road user. So the hazard triangle is used as a warning to other road user and should be used when the car is stopped. So it was a sign to other road user, but Mr. John didn't do that. So even though there is no rule, but as a reasonable man, Mr. John should do that. So, Young Arif, Mr. John's action of waving for help on the road is seen something unlawful for a reasonable man would do in that manner the highway because it's generally known that the users on the highway drive speedily unlike on the normal road.
Young Arif, now I will start my rebuttal. As for rebuttal for the defendant claim that Mr. John standing in the middle of the road, it is irrelevant to assume that Mr. John were stopping in the middle of the road. As for the case, if we assume it so, there will be other driver that will be involved in the car accidents. As per Young Arif, since as it happened on the highway which normally the density of road traffic user is high due to it being an expressway. Thus, Young Arif, assuming that Mr. John being in the middle of the road is inconsistent and irrelevant with the fact that only Aminah, who turns out driving recklessly, involved in the accidents. Therefore, Yang Arif, I rest my contention.
So, Yang Arif, now we are going to give our rebuttal. So, the counsel from the plaintiff side argues that the speed limit for driving on the expressway is 90 km per hour. It must be noted that 90 km per hour will be only used when the driver drives his or her car at the dangerous mountainous stretches, crosswinds areas and urban areas. The default speed limit for driving on the expressway based on the National Speed Limit Order 1989 is 110 km per hour. The counsel from the plaintiff side did not make any research on the Duke Highway where the expressway does not have dangerous mountainous stretches and it was not located in the crosswinds areas nor urban areas. So the counsel from the plaintiff cannot simply use 90 km per hour in his present case.
Thank you both counsels. The court is adjourned.